Today we're going to talk about a policy that has no Federal Register notice, and unfortunately that's all too common in the immigration law practice. The president just announces one day that he wants a policy to exist, and then the next thing you know, there are guidelines posted somewhere on the internet, and without any opportunity for any public input, suddenly you have a policy or a program, complete with a set of rules that no one's ever tried to discuss with the public. And in this video, I'm talking about President Trump's Remain in Mexico program, also known as the Migrant Protection Protocols, or by its initials, the MPP. It is the most inappropriately named program, as it has absolutely nothing to do with providing protection for migrants. In fact, it does the exact opposite. It places migrants in ongoing danger as yet another disincentive to try to apply for asylum in the United States. There will be a link to the Homeland Security website, which essentially establishes this policy through a set of FAQs. The policy really is fairly simple. If you are a migrant from a country other than Mexico and you come to the United States seeking asylum, even if you are found to have a credible fear, you're going to be sent back to Mexico, where you will have to wait for your hearing before the immigration court comes up. Now, there are tons of problems with this program, not the least of which is the fact that there is a complete lack of legal authority for it to operate. And we'll talk about all of that in just a few moments. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. So, how does Remain in Mexico work? Well, a migrant comes to the port of entry and they tell a CBP officer that they fear returning to their home country. Now, in the past, they would be processed, they would be taken into custody, they would be detained, and they would be given a credible fear interview by an asylum officer as soon as an officer becomes available. Indeed, at times, the credible fear interviews have been conducted by telephone with the asylum officer as far away as San Francisco due to the scarcity of interviewers. If the migrant has a lawyer, well, the lawyer can participate, but in most instances by telephone. And even then, the lawyer is not supposed to act as an advocate. The lawyer is acting as an observer. Now, if the interview results in a positive finding of credible fear, then the migrant is placed in removal proceedings. There, the migrant will have an opportunity to file an asylum application and present his or her case before an immigration judge. And in the past, there would be a procedure to determine whether or not to release the migrant on bond pending that immigration hearing. But that's not happening now. Now, if you have a positive credible fear finding, you will be giving a notice to appear, which will tell you the date and time of your next court appointment. Then you are given a list of potential lawyers who are pro bono or low cost, and then you are expected to contact those lawyers on your own. You're then given a piece of paper with a date, a time, and a location to show up so that you can then be transported to appear before your next immigration court hearing. And then you're sent back to Mexico. Now, in practice, the courts on the border with Mexico have been so overworked that they may not be able to give you an exact hearing date and time. Sometimes they schedule an entirely make-believe hearing date and time, sometimes listed as a time when the court's not even open, such as 1 a.m., and you're told that as soon as this space clears, your hearing will be moved up and you will be contacted. But how? You see, these people are people who fled from their homes in Central America with nothing but the clothes on their backs. They have no addresses. Indeed, they're often living in literal tent cities that have popped up just outside the ports of arrival. There may very well be no way to contact that person if there is a change in their court date. But let's add a complicating factor. In order to ensure that as few people are being taken into custody inside the United States as possible, the ports are limiting the number of people who can have credible fear interviews each day. So they limit how many people they process at the border. And as far as the United States is concerned, it's a first come, first served basis. They don't really care how long people in that tent city may have been waiting. They don't care if someone just pushes ahead to the front of the line to the detriment of people who have been waiting weeks, if not months. So, in order to provide some sort of order and fairness, it's the migrants themselves who have developed a system of creating and maintaining a waiting list by literally writing down the names of families who are waiting to have this credible fear interview in a series of spiral notebooks. Now, let's talk about migrant safety. There is none. That is the entire joke of the program. It's named after migrant protection, but there's absolutely no protection being provided to the migrants. You see, the area around Mexico's northern border with the United States is controlled by the Mexican cartels, such as the Zetas. They are dangerous criminal organizations who smuggle drugs and other contraband, such as humans who are then used for slave labor and sexual servitude, into the United States. They are people who have been known to rob, assault, rape, and even murder migrants who wander into their territory. And now, well, the cartels have easy targets. They just monitor the borders. And when they see that people get hearing dates and are returned back to Mexico, well, they find out who has relatives in the United States who has money. And then they kidnap that person and they hold them for ransom, threatening to kill them if their family in the United States doesn't pay up. And the sad part is that these cartels have a more efficient and humane way of tracking people who they have kidnapped and gotten the ransom for and who they released once the ransom is paid than the United States has of tracking the people who have court hearings. And it's a very sad day when the Mexican drug cartels have a more humane system to treat asylum seekers fairly than the United States has. But as I said, that is by design. The United States wants it to be known just how horrible these conditions are, so that it creates a disincentive for more asylum seekers to come to the United States. And it has been said way too many times in the past 4 years, cruelty is the policy. So, what is the legal authority of the United States to do this? Well, there is none. You see, the United States government has tried to cite a section of the Immigration and Nationality Act, but that section is just not applicable. And to demonstrate, let's go over the law. The law addressing how to handle aliens who arrive at one of the ports of arrival is set out in Section 235 of the Immigration and Nationality Act. All aliens who arrive at a port of entry are considered to be treated as applicants for admission into the United States. And there are legal rules why a person may or may not be admitted to the United States. The rules that keep people out of the United States are called the grounds of inadmissibility. The statute divides the aliens believed to be inadmissible into two categories. The first are those aliens who have arrived at a port of arrival either without a visa or with fraudulent paperwork. Section 235b(1) provides that if an immigration officer determines that a person is inadmissible either for having no paperwork or for having fraudulent paperwork, the officer shall order the alien removed from the United States without further hearing or review unless the alien indicates either an intention to apply for asylum or a fear of persecution. That's called expedited removal. Generally speaking, aliens in this category are not entitled to a court hearing unless they are filing for asylum or express a fear of persecution. And if that alien does express such a fear, well, then that section of the statute provides that he or she is then referred for a credible fear interview. And if the interviewer finds that the alien does have a credible fear, the statute then provides the alien shall be detained for further consideration of the application for asylum. Notice the mandatory language used in this sentence. The alien shall be detained. There is no language saying that the alien can be sent to Mexico to wait for a hearing. Now let's compare that to Section 235b(2). That section addresses all the other grounds of inadmissibility, such as the criminal basis of inadmissibility, the national security basis, the public charge basis, mental health basis. The statute provides that if the examining immigration officer determines that an alien seeking admission is not clearly and beyond a doubt entitled to be admitted, the alien shall be detained for a proceeding under Section 1229A of this title. That's the provision addressing the removal proceedings before immigration court. But notice the language that Congress used as you go further in this subsection. In the case of an alien described in subparagraph A, who is arriving on land, whether or not at a designated port of arrival, from a foreign territory contiguous to the United States, the Attorney General may return that alien to that territory pending a proceeding. So, with respect to aliens who are subject to the grounds of inadmissibility other than having no paperwork or fraudulent paperwork, Congress granted specific authority to return such aliens to Mexico or Canada while their removal proceedings are pending. This is very important because what Congress explicitly provided with respect to one group of aliens, it withheld with respect to aliens who either have no visa or have fraudulent paperwork. Why, you may ask, would Congress do that? Well, simple. The aliens with no paperwork or with fraudulent paperwork are subject to expedited removal. That is, they could be removed without there ever being a hearing before an immigration judge. The only exception is if that alien claims fear, and then they can be placed in removal proceedings if they're shown to have a credible fear. And the United States is under treaty obligations not to return an alien to a country where his life or liberty may be in jeopardy. So, there is no legal authority to return asylum seekers to Mexico. Period. And this has been recognized by the Ninth Circuit in the case of Innovation Law Lab versus Chad Wolf, the acting secretary for the Department of Homeland Security, in a decision published on February 28, 2020. The court went further, addressing the issue of refoulement, Refoulement is the situation where an alien is removed to a country where their lives or liberty will be threatened on the account of race, religion, nationality, membership in a particular social group, or political opinion. By treaty, the United States has agreed not to engage in refoulement, and those rules have been enshrined in U.S. law directly through statute. That can be found at 8 U.S.C. Section 1231. It reads, "The Attorney General may not remove an alien to a country if the Attorney General decides that the alien's life or freedom would be threatened in that country because of the alien's race, religion, nationality, membership in a particular social group, or political opinion." The Ninth Circuit cited numerous pieces of evidence in the court record demonstrating that non-Mexicans who are returned to Mexico to await a removal hearing were being placed in danger of their life and liberty by the Mexican cartels. They are in danger because they're non-Mexican. They're in danger because of their nationality. Thus, the MPP violates the rule against refoulement. Based on this, the Ninth Circuit approved of a preliminary injunction issued by a district court preventing the Trump administration from enforcing its Remain in Mexico policy. Unfortunately, this was another one of those cases where the government applied for a stay, or an order preventing the injunction from taking effect, to the Supreme Court. The Supreme Court, voting 5-4, and without issuing any opinion addressing its reasoning, issued the stay. Therefore, the preliminary injunction is not in effect, but the litigation over the MPP continues. But once again, this shows the importance of what is at stake in the presidential elections. And should we have a Biden administration, the Biden administration will have to face this once it takes office. Joe Biden has committed himself to ending the Remain in Mexico program. But the sheer number of people living in those tent communities in the northern Mexico region is going to be a major challenge for his administration. Another unfortunate mess of what Trump would be leaving behind for President Biden. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.